Viewers, welcome back to the show. One of the things we do want in this show is interaction from the viewers. We do like your comments, Facebook and Twitter. Just like Rachel did, she sent in her query about a friend that didn't want to put in a claim for RSI. I think if you've got any issues or matters that you want dealt with, please forward to us your comments and we'll try and endeavour to deal with those issues on the show, won't we, guys?
Exactly.
And I think it's good because we do want to make this an interactive show. John, recently you had a construction worker who got a very big payout. What are the facts of that case?
Yes, Tony. My client, Tony, he was working at a concrete site. Concrete was being laid. Unfortunately, the concrete boom from the truck lost control and fell on him, fell on his foot, amputated foot, Tony, complex litigation, 5 defendants, Tony. The employer, the site manager, the site contractor, the actual pump operator, the pump truck operators. We had a recent settlement of $850,000 for a 40-year-old man who's had an amputated foot, plus the money of $230,000 he's already received in compensation.
So it's over $1 million.
It's over $1 million.
Nardine, can I ask you this?
Yes.
Why was there so many defendants?
Well, sometimes it's difficult to be able to prove liability to one party, as we had discussed previously.
So it's a problem of more than one person.
Exactly right.
And in this case, Tony, the squabble was amongst the defendants as to contribution, as to how much each party was going to pay.
So who was more to blame?
Exactly.
Yeah, and their respective proportions.
Exactly.
That's right.
Look, it's a great result for the worker. He's now able to move on with his life to some extent, but at the same time, he's going to have this injury for the rest of his life, Tony.
That's exactly right. Nardine,
Yes.
what concerns me is John's just got a decision over $1 million. Sadly, all the viewers out there are going to expect $1 million. It's very rare you get those sorts of cases these days. Is that correct?
100%, Tony. It is the work cover industry and the work cover realms is a minefield, and compensation can be hard to achieve, but nevertheless, it can be achieved.
So in very serious cases, there can be big settlements.
Exactly.
But in most cases, they do have to settle out of court. Is that correct?
That's right, just to avoid the risks
The
and
risks.
costs of litigation.
And the costs of litigation are very high, aren't they?
Very high, Tony.
John, there's a very important decision of Kochak. It's a decision that's on appeal now.
Yes.
But tell us a bit about the background to this case.
Tony, this is a decision of the Court of Appeal of the Supreme Court of Victoria. In essence, we have a worker that's, in this case, simply wanted the cost of his surgery to be paid.
Okay.
Work cover rejected that. Court proceedings were issued, which were subsequently referred to the medical panel.
What happens at the medical panel?
Well,
Nardine?
the medical panel unfortunately decided that his neck injury and the proposed neck surgery for the time wasn't related to his employment, and that any condition to his neck had effectively resolved, Tony, so therefore no payment had been made.
So let me get this right for the viewers. This particular person started off with a neck injury, wanted surgery, goes to the medical panel and they say that the neck injury is resolved. Why would he be having surgery? That flies in the face of common sense.
And not only resolved, Tony, but it's not a work-related injury.
So what are they saying, Nardine? They're saying that whatever the consequences are
That's
all
right.
pre-existing, is that correct?
And degenerative.
Degenerative, and work was not a significant contributing factor, Tony.
That sounds like a very harsh decision.
Now, the problem, as we all know, Tony, and the viewers, Tony, is that pursuant to Section 68 of the work cover legislation of the Accident Compensation Act, that decision of the medical panel is final and binding on the court. Now,
That's in relation to the surgery.
in relation to the surgery and statutory benefits, as in weekly payments and medical expenses. But work cover...
Oh, look, this is where the big butt is.
Exactly.
What's the butt in this case,
Well,
Nardine?
the plaintiff solicitors in this instance had attempted to pursue a serious injury for the claim, but the defendants had said that they couldn't do so because of reasons of the medical panel decision,
All
Tony.
right. So it's a separate claim altogether.
A separate
We've gone away
claim?
from the original claim of medical expenses and also statutory benefits, and now we're going for common law damages. Is
That's
that correct,
right.
Nardine?
That's right, Tony.
And what did the court find?
Well, the court had found at the Supreme Court of Victoria that although the medical panel reasons were inadequate, that medical panel opinions in instances like this are binding and are enforceable. So it just gives to demonstration that the work cover elements are all a minefield.
So, John, in effect, that medical panel decision shot down any future rights she had. Is that correct?
Exactly. A statutory benefits opinion by the medical panel has now been used against the worker in that she has no common law rights now.
It's a pretty significant decision, isn't it?
It's disastrous for the worker and potentially disastrous for the system, Tony.
Well, I think so. And Nardine, as a lawyer, you've got to be extra cautious, don't you?
We do. We have to seek very careful instructions from our clients and advise them the pros and the cons of any avenue that decide to take in their work cover case.
So, in effect, you're basically saying if you can avoid going to a medical panel until we get a final decision from the Court of Appeal, you're probably best to avoid it. Is that correct?
Well, Tony, exactly. And in effect, even though work cover won in this instance, they are the ones that are appealing this decision, Tony, because they now realise the full ramifications on the scheme, that a medical panel opinion can be binding on all aspects of a work cover claim. Tony, it was never in the intent of Parliament, of Jeff Kennett, who passed the laws regarding medical panels back 15 years ago, that a medical panel decision would be binding on common law damages claims. It was never the intent.
Nardine,
Yes.
This has been appealed to the High Court of Australia. Do you think the decision will be overturned? That is the Court of Appeal of the Supreme Court.
Well, I would hope so, Tony. Like John had indicated before, the ramifications and the intent of Parliament had never been so in these types of circumstances.
And John, your view? Because, I mean, the
Tony,
law as it stood before.
It's very scheme sensitive. You would find that if this appeal was not accepted by the High Court, I wouldn't be surprised if there's a change in the actual legislation.
Do you think that will happen?
Oh, yes.
Look, I actually don't mind the decision. I'll tell you why. It gives you certainty in terms of where you're at
The problem...
and saves a lot of legal costs.
I understand that. The problem is you can have a medical panel decision that's 5 years old affecting your current serious injury application.
Okay.
And that decision could be totally outdated, yet it's adversely affecting and potentially stopping a serious injury application and common law damages claim 5 years later.
Okay. Viewers, the message I want to give you in this case is speak to your lawyers very, very carefully if you've got anything going to a medical panel, because this decision as it currently stands could impact on any future rights you have. So make sure you understand what they're telling you and what you're going to the panel for. We're coming to the end of the show. John, is there anything else you want to add?
Tony, apart from be wary of the medical panel in the sense that, yes, you're correct, in the sense that it is an easier system, but the decision can be final and binding.
Viewers, I want to thank you for watching the show. John, Nardine, thanks for coming on board.
Thank you.
Send us your Facebook and Twitter messages, and also stay tuned for future episodes, and please stay safe.